The Supreme Court has affirmed the eligibility of President-elect Bola Tinubu to contest the presidential election that held on February 25. The Apex Court, in a unanimous decision by a 5-member panel on Friday, held that an appeal the opposition party, People's Democratic Party, filed to challenge the legality of Tinubu's candidacy lacked merit. PDP had, in the appeal marked SC/CV/501/2023, sought Tinubu's disqualification on the premise that the Vice President-elect Senator Kashim Shettima allowed himself to be nominated for more than one constituency ahead of the 2023 general elections. It told the court that Shettima was nominated twice, both for the Borno Central Senatorial seat and for the vice presidential position. PDP argued that Shettima's dual nomination was in gross breach of the provision of Section 29, subsection 1, Section 33, 35, and 84, subsection 1 and 2 of the Electoral Act 2022 as amended. Consequently, aside from praying the court to nullify Tinubu and Shettima's candidacy, the appellate equally applied for an order to compel the Independent National Electoral Commission (INEC) to expunge their names from the list of nominated or sponsored candidates that were eligible to contest the presidential poll. Meanwhile, the Apex Court, in its lead judgment that was delivered by Justice Adamu Jaro, held that PDP lacked the locus standi to interfere in affairs of the ruling All Progressive Congress (APC), which nominated both Tinubu and Shettima for the presidential election. The Apex Court upheld the concurrent decision of the Court of Appeal and the Federal High Court in Abuja, which earlier dismissed PDP's case. It agreed with the respondents that Section 285, subsection 14, subsection C of the 1999 Constitution as amended, and Section 149 of the Electoral Act 2022 did not confer the locus standi to challenge the candidature of Shettima on the ground of double nomination. The Apex Court held that Section 84 of the Electoral Act only empowered an aspirant that participated in the primary election of a political party to challenge the nomination of a candidate by the party. It held that the PDP failed to establish the injury it suffered as a result of the nomination by the APC, stressing that the law does not permit a political party to dabble in domestic affairs of another political party. The Supreme Court said the PDP was unable to prove that its civil rights and obligations were in danger of being infringed upon. It described the appeal as the action of a nosy busybody and a meddlesome interloper that is peeping into the affairs of its neighbor. More so, the Apex Court berated the PDP for filing the appeal, which he said was frivolous and capable of exposing the judiciary to public ridicule. The Apex Court held that evidence before it showed that Shettima duly withdrew as the candidate of the APC in Borno senatorial election on July 6, 2022. In whichever angle this appeal is viewed, it is frivolous and bound to fail. From the trial court down to this court, it has been a waste of precious judicial time. The instant appeal was unnecessary and counsel should do better to advise their client against filing this sort of suit in future. Justice Juro made that known. While dismissing the appeal, the Supreme Court okayed 2 million naira damages that was awarded against the PDP in favor of the respondent.